Hi, this is John Linneball from John Linneball Tutoring. You can reach me at this email address. There's my website, here's my phone number, and here's my mailing address if you want to contact me about tutoring. Today we're going to discuss legal words. This is Legal Words Part 1. What we're covering here: words pertaining to criminal and civil law as well as everyday situations. We'll also cover a few other relevant fun facts. If you like this video, please don't forget to give this a thumbs up, subscribe to my channel, and click on the little bell in the top right corner for notifications. Whom this is aimed at. First of all, people from outside the United States who might want to come to the United States to study, or they might be here for a job, or whatever, if you just want to know about the U.S. legal system. High school and college students who'd like to increase their vocabularies for the SAT, ACT, etc. Someone who might want to study law in the U.S. or possibly England. Or anyone who wants to learn legal terms in English. Important legal disclaimer. Nothing discussed here is legal advice. If you have a legal problem, go see a lawyer in your jurisdiction, or the jurisdiction where whatever legal problem you have might apply. I believe any excerpts from copyrighted materials used in this video fall within the fair use exceptions, parody, commentary, etc. to any applicable copyright laws. If you don't like the way I've used your intellectual property in this or any other video, please contact me before you complain to anyone else. You can contact me using the information I give you at the end and at the beginning of each video. Thank you. When words get you in or out of trouble. Disparage. Disparage is when you're putting something down, you're making fun of it. So there have been laws actually called food disparagement laws. I believe they were passed in like 1997, and they themselves were disparaged as, in quotes, veggie libel laws. So here's some information that came up here, the Texas Food Disparagement Law. And it talks about under Texas's food disparagement law, persons are liable for damages and any other appropriate relief if they disseminate information that states or implies that a perishable food product is not safe for public consumption, provided that the information is false and the persons know or should have known that it was false and likely to damage. So how Oprah got sued for dissing a burger. So these are just ways that food producers can sue their critics for libel. It's kind of related to, well, it's just related to trade libel. You can sue if somebody puts out false statements that damage your business. So anyway, getting back to this. Disgruntled refers to gruntles, which are little grunts made by someone who's unhappy. In this case, the dis does not mean not. So it's a joke that I saw. Someone said, oh, well, if you're not disgruntled, if you're really happy, are you perfectly gruntled? And the answer is no. I did look this up online, and it's just a very old kind of medieval thing. So gruntles, where if you're going, you're upset because you're grunting because you're upset. So dis does not mean not. It's kind of like when something is inflammable, that means the same as it being flammable. In that case, in doesn't mean not, even though it normally does when you use it as a prefix. Defamation is to make intentional, knowing, false statements to damage someone's reputation, like libel. Libel is defamation when it's written, thus the food libel law, food disparagement law. Slander is defamation that is oral, that is, it is spoken. So libel and slander are both types of defamation, just libel is written, slander is spoken. Inculpate, that's a word you don't hear every day. It means that it shows that someone is guilty. Exculpate, you hear more often. That shows someone is innocent. So exculpatory evidence would be evidence that tends to exculpate someone to show they are innocent. I believe there is a Supreme Court case called Brady versus Maryland that requires prosecutors to turn over all potentially exculpatory evidence when defense counsel requests it. There have been TV shows and movies based on that principle. Exonerate is to be proven innocent, and that's related to onerous. Onerous means harsh, punitive, something that's really burdensome, really hard to do. So an onerous punishment would be a really burdensome punishment. Onus is a duty or responsibility. That's where onerous comes from. So you can think of own. A lot of people say when they want you to take responsibility, you're going to have to just own that, mister, something like that. Turns out own and onus have completely different roots, at least according to the dictionary that I looked at, but it's an easy way to remember it, so I am okay with that. Civil law. Now, civil law, it's all about the money. It's all about the Benjamins. Civil law is dealing with money, property. You could get an injunction from a court where someone is ordered not to do anything. This is not criminal. There is no chance of jail or prison from a civil judgment itself. There is one exception, that if you violate a civil order, that is called contempt of court, and that is a crime, and that can get you put in jail or prison if you are dumb enough to do it, especially repeatedly. See, courts really don't like it when you disobey them. The legal system does not like it when you disobey it, so don't do that. Anyway, back to civil law. The person filing the lawsuit is the plaintiff. Complaint, what you say or write when you don't like something and want someone to do something. It's also the first document filed in a lawsuit. So plaintive, according to Google, means sounding sad and mournful. So it's like you're complaining, oh, my life is so bad, I'm sad and mournful. Okay. The person being sued is the defendant. He, she, or it can be a legal entity such as a corporation, must answer the complaint. So a corporation is a legal, in quotes, person that can sue and be sued. Some other entities, such as nonprofit organizations, are also legal people, even though they are not biological people that can sue, can be sued. They have many of the same legal rights as actual human beings or natural persons, natural people. Civil words, contracts. Contract versus tort. Contract is based on an agreement, a contract, which can be written, oral, or implied. So a written contract is exactly what you think, like this picture in the background. It's 5-10 pages of legalese. Oh, the party of the first part, party of the second part, blah, blah, blah. There's actually a trend towards plainer language in legal writings, including contracts, but it's usually still not something you want to read for fun. And that's something that you both sign and might even have notarized or something, so you have a contract. But a written contract doesn't have to be that. It can be anything. It can be an email. It can be a receipt. It can be a ticket. It's just anything that's supported by a writing. An oral contract is based on spoken words. There are obvious proof problems if nobody else but you and the other party to the contract heard it. How are you going to prove what was said? So that's led to statements such as, an oral contract isn't worth the paper it's written on, which was attributed to Samuel Goldwyn in 1937, but it's appeared in writing as early as 1890 when Samuel Goldwyn would have been about 11 years old. And here's the website you can go look at, quoteinvestigator.com. So, but those old-time Hollywood guys, they had some pretty hard-nosed things to say, so that is one of my favorite sayings, is an oral contract isn't worth the paper it's written on. And in case you're wondering what an implied contract is, that's something like when you go to a store, you see a price on something, you go up to the cash register with the price tag on the thing, you know you're going to pay that, plus maybe some sales tax. You're not going to go and negotiate with the clerk at the 7-Eleven. Well, I know it says $1.99, but I'm wondering, would you take $1.69 instead? That's not going to happen. Okay, so that's an implied contract. We all understand. You see the price, you know that that's what you pay. Contract law. Contract law differs from tort law in that it is intended to promote economic efficiency. That is, to make it easy to do business, and lawsuits are generally limited to making the wronged party whole, not to punish the wrongdoer, soothe hurt feelings, condemn the actions, that kind of thing. So the idea is you get the benefit of the bargain. So if you would have made $10,000 on a business deal if the defendant hadn't breached the contract, you'll get your $10,000 plus maybe interest, attorney's fees, things like that if you are 100% in the right and you go to a judgment. You're not going to get punitive damages or, things that are just added on because what the other person did was bad. Why? Because they want to encourage efficiency so that if the guy who was going to sell you some product wholesale that you could have sold retail and made $10,000 on, if he's selling you that for $5,000 but he can turn around and sell it to somebody else for $20,000, then it's actually worth it to him to breach the contract, pay you your 10 grand, and then get, he's getting 20,000 instead of 5,000, so that's 15,000 he makes. Even if he has to give you 10,000, he's still ahead $5,000. Well, okay. Something like that. So it does encourage economic efficiency. It encourages what I believe is called the economically efficient breach. Breach of contract and more. So a breach of contract is, as I've implied, not living up to your end of the bargain. So here we have someone tearing up a contract. Here's what I think of your contract. All right. A material breach is a breach that matters. So you can think matter is material. It's stuff, right? It's a thing. If it's immaterial, it doesn't matter, and it's not a thing. A claim based on it won't succeed. So if it's irrelevant, if it's immaterial, it's going to be something like, you agreed to deliver this at 11 a.m. Your truck didn't pull up until 11:01 a.m. Okay, in what way were you damaged? Well, I had to wait there for a minute. Probably not going to collect any damages based on that. An anticipatory breach or anticipatory repudiation is where one party acts in such a way that it shows it does not intend to honor the contract. Repudiation is rejection of a proposal or an idea, or the denial of a truth of an assertion. So if you're just saying, I don't have to do this, I'm not going to perform on this contract, and if you don't like it, sue me. Well, guess what? In court, that's exactly what you're doing. You are suing. So if somebody makes it clear that they're not going to carry through on a contract, you don't have to wait for them to actually not perform. You can, actually sue based on, the fact that they're obviously not going to perform on their contract. So you can see also Sarah Palin's refudiate. She inadvertently confused and combined repudiate and refute to show that something is false. I actually like that word. So, refudiate is pretty cool. All right. Other contract defenses, a mutual mistake. Both sides had different ideas as to the main point of a contract. A common mistake is where both sides had the same mistaken idea. So if I offered to deliver something to LA and the person thinks I mean Louisiana and I mean Los Angeles, that's going to be we both had different ideas. It's a mutual mistake. Common mistake, maybe we both thought that something was legal in a jurisdiction when it turns out to not be legal, so we're both mistaken on that, and maybe we just are both excused from the contract because it's illegal. Courts generally aren't going to enforce things that are against the law because their job rests on enforcing the law and not ignoring the law. All right. So frustration of purpose, when one or both parties know the contract was for a specific purpose, but that purpose was defeated by an event outside the party's control. I have a contract with you to paint your house. There's an earthquake. Your house is completely destroyed. I can't say, well, you have to pay me to paint the house. It doesn't work that way. The house is no longer worth painting. It's been destroyed. Impossibility, it would be impossible to perform on a contract. Again, let's say to clean a house or paint a house that had burned down before the performance date. Okay, what am I going to do? Paint the ashes, clean the ashes? That's not going to work. Commercial impracticability, even if it's not impossible, it's something that wouldn't be practical or wise. Nobody in the industry would actually abide by that contract because it's extremely expensive, burdensome, or onerous. So that's a more relatively modern approach that in the old days, I think you could actually be sued for something that was possible, but no one would really do it. But now it's a defense, commercial impracticability. So if it's something no sane person would do, you can probably get out of a contract based on that. Tort law. Okay, so we mentioned tort law before. Tort law is based on just general civil rights. So you can think of a personal injury case like this unfortunate person who slipped on a banana peel that was negligently left somewhere by someone. So, property liability is one way that people make money. It's in tort law, it's slip and fall cases, so you might see it in public places that are supposed to be kept clean. So you can think distort, literally to twist or bend out of shape, or torture, to twist someone's body or mind so it hurts. So it's the same thing, you've basically twisted somebody's rights, you've caused some sort of problem. Intentional torts include assault, battery, false imprisonment, defamation, something that you can't do by accident. You had to intend to do it. Negligence, as far as I know, that's really the only non-intentional tort, which covers lots and lots of different things. There are many different kinds of negligence, but basically negligence is the only non-intentional tort. It's also the most common because most people don't run around doing intentional torts to people, or at least they pretend they don't. And so a good way to take care of those issues where you can't prove that somebody meant to do something or they really didn't mean to do something is you can say, well, you were negligent, meaning you should have been able to avoid this situation. You were in a position to prevent this from happening, but for some reason you didn't do that. So professional malpractice. Premises liability here. If somebody at your supermarket failed to clean up a banana peel that somebody had left on the floor, that would be negligence. All right. Limiting words. Okay, this deals with statute of limitations. For example, accrue. Accrue means to start or accumulate. A legal cause of action, in quotes, accrues at the time the plaintiff knew or should have known that she or he was injured, which starts the clock on the statute of limitations. Interest accrues on a loan or a legal judgment. The longer you take to pay, the more it will cost you. Or the longer you keep your money in a savings account or money market account, something like that, the more money you will make in interest, the more interest that accrues when you just leave it alone and let it gain interest. Statute of limitations, the time you have to file a civil action, that is, sue someone. It's also the time the state has to file criminal charges against you. So laches is related to the statute of limitations. It's a legal word. It means you waited too long to file a claim, and it wouldn't be equitable, which is a fancy legal word meaning fair, to allow you to sue. So it's very similar to the statute of limitations. So remember statute of limitations, you can think police dramas, movies, TV shows. You always hear, there is no statute of limitations on murder. So think cold case files, shows like that, right? Where it's a murder that was 20 or 30 years ago and they suddenly find new evidence. Nobody gets away with saying, ha ha ha, too bad you didn't catch me in the 1980s, you can't do anything. They'll just say, there is no statute of limitations on murder. All right. Trial words. Voir dire, the process of jury selection. Peremptory is a kind of challenge that an attorney can make. So from Google, I looked it up on March 14th, it's especially of a person's manner or actions. It's insisting on immediate attention or obedience, especially in a brusquely imperious way. Brusque means very rude and abrupt, and imperious means like an emperor, imperial, where you're saying, you must do this right now. So in law, it's not open to appeal or challenge, final. The attorneys on both sides of a legal case get a certain number of peremptory challenges where they don't have to explain to the judge or the other side why they don't want a particular juror on a jury. So during voir dire, they may use their peremptory challenges. So as it says here, peremptory challenge is a lawyer's dismissal of a juror without cause. Attorneys only get a few peremptory challenges. Additional challenges generally have to be for a stated cause. So maybe for a conflict of interest. You don't want a juror who is best friends with the defendant at the trial or best friends with the plaintiff for that matter. Generally you're going to want people who have never met the plaintiff or the defendant, etc. And additional challenges generally would have to be for a stated cause, as I just said, and approved by the other side and or the judge. There are more trial words. We can recuse. A judge's voluntary withdrawal from hearing a case because of a conflict of interest. Again, if the judge is the defendant's best friend, you might say, okay, I know you two are friends, Your Honor. You have to recuse yourself from this case. Conflict of interest is when you are anyone expected to make an unbiased, that is a fair decision, such as a judge has a reason to make a biased decision. Again, if it were my brother and I were the judge, Certainly the person suing my brother might say, yeah, you have to recuse yourself, Your Honor, and you know that. It doesn't have to be in court. It can be any government official or anybody else who's being expected to make an unbiased decision. So that also brings us to disinterested versus uninterested. Disinterested means what we're talking about here, unbiased and fair. Uninterested means that you're bored by something. So a disinterested judge would say, no, I don't know either of you. I don't have any strong feelings about the subject matter of this case. I can be completely neutral and disinterested. Uninterested would be if the judge were acting like a 12-year-old and said, this case is boring. Can you take this to a different court? I don't like this. Okay. A judge would never do that, but that would be what uninterested, or they might just say, okay, tell me about the case. So, an uninterested judge, I don't know. Not sure. I'm sure judges are uninterested plenty of times. Doesn't really hurt very much, but disinterested is important. You need the judge to be disinterested. I guess uninterested, okay, come to think of it, it could be bad if the judge is just so uninterested that they're not paying attention to important parts of the case. That might actually be grounds for appeal, which we'll discuss in a little bit. Criminal law. An arraignment is when you're brought into court to plead guilty or not guilty. An indictment is being presented with criminal charges against you. For example, an impeachment, such as President Trump being impeached, is just an indictment where he's just charged with criminal charges. The trial after the impeachment is the actual trial. So, for example, President Trump was impeached, but he was not found guilty of any of the high crimes and misdemeanors of which he was accused. Presumption of innocence means innocent until proven guilty. The criminal standard of proof is beyond a reasonable doubt. That means 99% certain that the person is guilty, the defendant, I should say. The civil standard of proof is a preponderance of the evidence, 51% likely the defendant is liable. Clear and convincing evidence, halfway between civil and criminal, 75%. Pleading is guilty or not guilty, or nolo contendere, which means literally I do not contest the charges. And yes, it says here, nolo contendere, I do not contest the charges, and voir dire is questioning potential juries, not potential juries, potential jurors during jury selection. As we discussed, or let's say it's the middle of the night, you might have to call the judge at home, things like that. An inventory search is a search to list or inventory what is in a seized or stored vehicle. So if someone is arrested, let's say for drunk driving, and their car has to be towed to an impound lot, yes, the police are able to search the vehicle even though they don't specifically have a warrant to search the vehicle, because let's say somebody's car is towed and the person says, oh, I had all sorts of gold and jewelry and I had groceries in the trunk and those went bad and that was $300 worth of prime rib. The way that the police protect themselves is by inventorying the car's contents, so they can say, no, there was a sandwich that went bad and you had a broken Timex watch. That's all that was in the car when we inventoried it. So pretty sure you're making up all the rest. Okay. Exigency or exigent means basically emergency. So exigent circumstances may allow a search without a warrant. I'll say that again. Exigent circumstances. See, I can say it. All right. That may allow a search without a warrant. If someone is yelling, help, 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 help out the window, help police, please come help me, Mr. Police Officer, the police officer does not have to go get a warrant to enter that person's apartment or something to provide that person with help. That would be an exigent circumstance. Plain view. Plain view means something can be seen from a public place that a police officer or any member of the public would have a right to be in. So the police don't have to have probable cause or a warrant to deal with things that are in plain view. For example, If a car is driven through a stop sign and the police pull over the person for driving through the stop sign without stopping, well, driving past the stop sign, not through the stop sign, that would be a pretty serious offense. Anyway, they're pulled over, routine traffic stop. The police officer sees a baggie of suspicious white powder and an AK-47 sitting on the floor of the car. The police officer doesn't have to get a warrant. The police officer can immediately search the car, arrest the driver, etc., because it was contraband that was in plain view. It's also one of those things that can apply in weird situations, such as there's a hot pursuit exception to the Fourth Amendment. This has happened, believe it or not. It was also in a Dirty Harry movie back in the day, but anyway, where a police officer was chasing a criminal suspect who ran through somebody's house. Turns out the random house that he chose to run through was a place where drugs like marijuana or cocaine or something were being packaged. So the people packaging the drugs in their living room got busted. Of course, they said, well, the police had no right to come and search our home because they had no reason to believe anything was going on, and the court ruled, well, no, the police officer was in hot pursuit and just happened to see those things in plain view. Got into an argument with somebody about that once on the internet. Same idea. Anyway, they're like, well, why would the police be in somebody's house? Well, they could end up in your house under circumstances that you don't control. What if somebody else breaks into your house or is running through your house and the police are chasing them? So, well, the rule is generally just don't have illegal things in your house, but anyway. The Fifth Amendment is the U.S. Constitution's protection against self-incrimination. I refuse to answer the question on the grounds that my answer may tend to incriminate me. So you might be asking, well, why are people allowed to do that anyway? That just seems silly. I mean, if you can't tell the truth without incriminating yourself, maybe you deserve to incriminate yourself. Okay, there is a really important reason why that we don't allow people to incriminate themselves, or at least that we allow people, I shouldn't say we don't allow people to incriminate themselves, we do that all the time, but we do allow people to say, oh, I can't answer that question without incriminating myself, or I may be incriminating myself. And that's why you have the right to remain silent under the Fifth Amendment. You don't have to say anything, and they can't say, aha, an innocent person would proclaim his innocence. He would not just simply remain silent. You cannot infer anything from that. And the reason that you want to allow people not to incriminate themselves is to prevent torture.
All right, let's go. Nice job.
Say nothing, you understand? Get a lawyer!
The idea, many unfortunate times in history, people were just beaten or otherwise tortured physically or psychologically until they finally just broke down and said, okay, I committed this crime, even though there's no way that actually happened. So the way to help prevent false confessions is just not to allow people to be harassed if they've already said, I'm not going to talk to you. So that is the Fifth Amendment right against self-incrimination. Crimes. There are a lot of different crimes. Some include conspiracy. Conspiracy involves planning to commit a crime. Common law definition of a conspiracy is two or more people agreeing to an illegal plan. Some jurisdictions, the people making the conspiracy must also take some sort of affirmative act to carry the conspiracy out. So here I have a little quote from Stephen Hawking. If the government is covering up knowledge of aliens, they are doing a better job of it than they do at anything else. So that would be an example of a conspiracy theory. So here we have some other things about conspiracy theories. Conspiracy theory is usually just a far-fetched set of ideas about powerful entities secretly doing bad things. If you want to have some fun, you could Google Illuminati or you could Google tinfoil hat. That's just an old saying, old kind of anecdote about somebody thinking the CIA or some other agency was shooting mind control rays at his head, so he'd wear a tinfoil hat to bounce the rays off, so his mind wouldn't be controlled by mind control rays. And here we can see some other conspiracy things, like the moon landing was faked, or the face on Mars, or what the symbolism of this weird pyramid on the back of the dollar bill is anyway. And of course, there are numerous conspiracy theories about JFK and why he was assassinated and who did it. So anyway, but those are conspiracy theories. Here's another word you probably would want to know, an accessory. Now, we know an accessory can be something that goes with your cell phone, or might be something that matches your outfit, like your belt or your shoes or something like that. And so someone who helps another person commit a crime is also an accessory. That's a bad kind of accessory. So you are an accomplice or an accessory to a crime if you help someone commit a crime. And one interesting fun fact is you can be an accessory after the fact. How can you do that, you ask? I'm glad you asked. You can actually be an accessory after the fact by helping somebody escape after they commit a crime. So if your best friend says, oh my God, the police are after me. Can you please hide me in your basement? If you do it, you're an accessory after the fact. You can be charged with whatever crime your friend committed. So, and you also can be charged as an accessory if you help them at the time doing it, so don't do that. More crimes. An assault. An assault is putting someone in fear of a harmful or offensive bodily contact. So, the way I usually like to describe it is, if I pull my fist back like I'm about to hit you, that alone is assault. I don't have to actually make contact with you as long as I put you in a legitimate fear of an offensive or a harmful bodily contact. Battery is actually making a harmful or offensive bodily contact. So if I actually punch you, that is a battery. If I grab you in a naughty place, even if it doesn't hurt or doesn't cause damage, it could be considered offensive. So that would also be a battery. Grievous bodily harm. So that's used in some jurisdictions to describe serious physical injury inflicted on a person by the deliberate action of another. So deliberate means that you have actually deliberated, you had enough time to actually think it over, roll it through your mind, and decide, yep, I'm going to do this person grievous bodily harm. So deliberate and intentional are not the same thing, and intentional can take a split second. You're like, yep, I'm going to do this. Whereas deliberate, you've had a little bit more time to think it through and you still decided to do it. Mayhem. According to the Google Dictionary, mayhem is a violent or damaging disorder, chaos. So here's a character called Daisy Mayhem that was on Scooby's All-Star Laugh-Olympics. I remember this from when I was a little kid. So she was a female hillbilly and a member of the Really Rottens, and her name was a play on Daisy May, a character in the comic strip Lil Abner, which is ancient. Anyway, Daisy Mayhem. Get it? Ha ha ha. So historical in law, it was the crime of maliciously injuring or maiming someone, originally so as to render the victim defenseless. And in more modern criminal codes, mayhem was defined as permanently injuring or crippling a body part. So here we go. There are even more crimes. Larceny is taking something from someone with the intent to permanently deprive the person of that thing. So it's stealing something from somebody. Robbery is taking something from someone with the intent to permanently deprive the person of that thing. So it's larceny, but it's using force or the threat of force. So it's basically larceny carried out by assault. The idea is your money or your life. I'm going to shoot you if you don't give me your money. That's robbery. Larceny, you drop your money or you put your wallet down for a second, forget you put it down. I take it. That's larceny. Burglary, common law, is breaking into someone's dwelling at night with the intention of committing a felony therein. Notice that is ancient English common law in the U.S. and pretty much every jurisdiction. It's against the law just to break and enter into somebody's dwelling house into somebody's property, no matter what your intentions were. So you don't have to say, oh, well, I only intended to commit a misdemeanor or something like that. Breaking and entering is generally a crime, but that is burglary at common law, is you have to break into someone's dwelling at night with the intention of committing a felony therein. So if you break into someone's shop during the day under English common law, well, that's not a dwelling and it's not at night. And I actually didn't intend to do anything other than commit the misdemeanor of trespassing or something like that. Okay. That's why it's important to break laws down into the elements that you actually want to prohibit. Okay. And here we see some cartoons. Here's a little cartoon burglar. And this is a robbery. Ha ha ha. And the fat cat executive who's walking away with a huge bonus says, ha, amateur, you don't know what a real robbery is. Ha ha ha. Okay, appealing words. An appeal is when you are asking a powerful person or entity for a favor. So here we have an old flag this is a pine tree flag from the Massachusetts colony in the Revolutionary War times. It's an appeal to heaven. This is a modern redrawing of it, but anyway. In legal terms, you appeal to a higher court to overturn what you believe is a bad ruling by a trial court or a lower appellate court. So if you don't like something the trial court did, you can appeal to the next higher up appellate court. If you don't like what the appellate court did, you can appeal to a higher appellate court until eventually you get to either your state Supreme Court or the federal U.S. Supreme Court. Usually once you've reached the Supremes, you're done. As the old joke goes, a lawyer appealed his criminal client's case all the way to the Supreme Court and lost. So the criminal asked him, what do we do now? And the criminal lawyer said, well, I go home, you go to prison. It's not really that funny of a joke, but anyway. So something that is appealing is something that's attractive. It appeals to others' sense of beauty, goodness, or other qualities to make others want it. So if you're appealing to a higher court, you're going to say, well, come on, the law requires you to do this, and this court didn't do it. You have to overturn this, Your Honor, because this judge didn't follow the rules, and it's not fair to my client, and it's wrong. Something like that. More appealing words. Transcript. A transcript is a written record of a hearing. So you've probably seen TV shows or movies where they have somebody clicking away on a little stenographer's machine. That's a court recorder. The transcript is a written record of the hearing. A certified copy is an official, guaranteed accurate copy of a record. It's often used on appeal. So, for example, a writ of certiorari is the U.S. Supreme Court's way of asking for a record. If you want to appeal to the Supreme Court, it's called a petition for a writ of certiorari, and that is, you're asking the Supreme Court, could you please order a certified copy of this record so you can review this? And when they say yes, okay, certiorari is granted. When they say no, which of course the vast majority of times it is, it's cert is denied. So de novo. Well, de novo literally means new, like innovative means new, novel means new, so nov means new. De novo is where the court reviews the record from the trial court and makes an independent judgment. That's the opposite of abuse of discretion, which we'll discuss in just a minute. En banc means when an entire court of appeals, rather than just a 3-judge panel, hears an appeal. So with the federal courts of appeals, usually it's just a 3-judge panel that hears it. You can ask for a rehearing en banc if you feel it's so important that every judge who is on the court of appeals should actually weigh in on that ruling. And then the court itself decides whether or not it's actually going to do that. More appealing words. Arbitrary means it's chosen randomly for no apparent reason. Capricious means something is done for no serious reason. Whimsical. So here we have a little joke about whims. Whim is when you just do something for no reason. At any given time, the urge to sing The Lion Sleeps Tonight is just a whim away. A whim away, a whim away, a whim away. Okay. So, an abuse of discretion is a misuse or an abuse of judgment or discretion. Many issues are within the sound discretion of the trial court, and an appellate court won't reverse the ruling, even if it doesn't agree with the trial court. However, where the record, transcript, and or orders, written filings shows a judge utterly failed to use good judgment, appellate courts can reverse. And the appellate court will say it was an abuse of discretion, often described as arbitrary and capricious, where the judge chose something randomly for no apparent reason, or it was done for no serious reason, or just a whimsical reason. Words behind bars. Incarcerate. To incarcerate means to imprison or jail someone. Imprisonment is preventing someone from leaving an area. See also false imprisonment, which is an intentional tort, which is making it so someone can't leave, or withholding someone's valuable property so it would be unreasonable for that person to leave. For example, there was a case I know I read once where somebody was buying a car or was looking to buy a car at a car dealership, and the car dealers took the person's car keys from the car that he or she drove to the dealership, wouldn't give it back to the plaintiff unless they bought a new car, etc. Well, so anyway, that was considered to be false imprisonment because the person, even though he was physically free to go, he wasn't going to leave without his car keys, since it's probably a long walk home and it's a valuable item, the car. Detain. To detain someone means to prevent someone from leaving a place. So some of you may have had what's called detention in high school or junior high school, middle school, etc., where you had to stay after school because you did something bad. So you're being punished by having to stay after school. The movie The Breakfast Club came out in the 1980s. This is about 5 students here who have what they call Saturday detention. My school system, the school system that I attended, did not have any kind of weekend detention. It was just after school, but apparently that happens in some school districts. And also there's a song by The Doors called When the Music's Over, where it says, "Send my credentials to the house of detention." All right, so that's what incarceration and imprisonment are. It's basically being detained by the state. Penitentiary. A penitentiary is a place where people can repent or be penitent for crimes and presumably stop being criminals and turn away from their crime. Reformatory, another idealistic name for a prison, it's a place where criminals can reform and go straight and stop being criminals. Now this is a jail. A lot of people pronounce it gaol. It's just the old British term for jail. It's the same as a jail. It's even pronounced that way. It's just an old British term still used in Australia and the United Kingdom. A gulag, Google says, it's a system of labor camps maintained in the Soviet Union from 1930 to 1955 in which many people died, or a camp in the gulag system, or any political labor camp. Habeas corpus is the great writ. It's literally a saying in Latin that means you have the body, where the jail/prison is required to show cause for jailing or imprisoning someone or particular conditions of incarceration. And that goes back, I believe, to the Magna Carta about 1215. That was a limit on royal power. That, the idea is a judge could actually force administrative, executive, such as kings and people like that, to actually show why is this person in prison, show us why this person is being imprisoned. You have the body, so we want to know why you have the body. Words behind bars, some more, okay, oops. Minor or funny laws. Mopery from Google, the action of committing a minor or petty offense such as loitering. So that's informal U.S. English, so it's slang. We got guys doing stretches for passing bad checks and aggravated mopery. So I'm not sure what that's from, but that was the example used by Google. Loitering is standing in one place for a long time for no apparent purpose. Wikipedia. In some jurisdictions, the definition of loitering may include indoor littering and the wearing of masks or disguises in public, such as New York. And here we have what looks like some Banksy graffiti art where no loitering, and then there's somebody sitting there in a rocking chair with an American flag. And I guess if you're sitting there rocking in a rocking chair, you'd be loitering there. Soliciting is begging as a vagrant or fundraising for charity. And you can see the description for a link to a list of funny laws around the world, and you can also Google funny laws and you will find lots and lots of pages that list silly laws that exist in the world. So, loitering, in case you're wondering, it's probably a crime just because the police were tired of seeing people hanging around and they just wanted to be enabled to stop crime before it started just by saying, okay, you look suspicious, you're hanging around this area for what cannot possibly be a good reason, so we can just arrest you for loitering. And here's a little sign, private property, no soliciting, loitering, trespassing, all offenders will be prosecuted to the full extent of the law. And that's one of those vague legal threats. Even if there's no law against loitering, well fine, then the full extent of the law is nothing. Let's move on. Laws of the land. Trespassing is going onto someone's property illegally. Real property is land. The idea is Latin for royal. Real means, royal, and of course translated to real. And it's granted by the king or the queen. Adverse possession. You can actually live on someone's property long enough that you get to keep it if the owner doesn't object in time. The idea is if it's hostile, open, and notorious. So if everybody knows you're there, it's hostile to the claim. The idea is, no, it's my property, but I've never gave you permission to be there, but I don't do anything about it. Then if you live there long enough, and it varies from state to state, you could actually say, no, I live there with a hostile claim to your claim of ownership. Everybody knew I was here. I built a house on it. I built a picket fence. I painted my name on the mailbox, etc. It becomes your property if I don't do anything to protect my right to own it. One neat thing I've heard you can do, though, is just tell the person who's on your property, oh, that's okay, stay there as long as you want. Because then the claim is not hostile to my claim if I say that. All right, fee simple means basically you own it all, it's your property. Fee simple can be subject to a condition precedent or subsequent, so it might be something has to happen for you to be able to own it, or if something happens after you take possession, you can have it taken away from you. So subject to a condition precedent, meaning before or subsequent after. A life estate means someone can have the right to live there until they die, but not to pass it on. Joint tenants are people who own land with a right of survivorship. So if you and I own land that way and I die, congratulations, you get my share of the property. Tenants in common, it's like joint tenants, but no right of survivorship. So you and I own property, the same property as tenants in common. I die, my share goes to my heirs rather than you, presuming that you're not one of my heirs. So not so good for you.
The year 1967. Drug-crazed youth discovered vagrancy as a way of life.
Vagrancy. Wikipedia, you can see the entry for vagrancy. Vagrancy is the condition of homelessness without regular employment or income. Vagrants usually live in poverty and support themselves by begging, garbage scraping, petty theft, temporary work, or welfare. And that's actually a crime in some places, but also in Wikipedia and Papachristou versus City of Jacksonville, the Supreme Court ruled Supreme Court of the United States, ruled that a Florida vagrancy law was unconstitutional because it was too vague to be understood. Prosecutions for vagrancy are rare because, well, there's a serious risk that it will be found unconstitutional under this U.S. Supreme Court ruling, but they're being replaced by prosecutions for specific offenses such as loitering. So that's vagrancy. And a little more about vagrancy. Both vagrant and vagabond ultimately derive from the Latin word vagare, which means to wander. Vagabond is derived from Latin vagabundus. Vagabond originally denoted a person without a home or employment. You may have also heard the word transient. Transient also means somebody who travels all the time or wanders. More Wikipedia. Historically, vagrancy in Western societies was associated with petty crime, begging, and lawlessness, and punishable by law by forced labor, forced military service, imprisonment, or confinement to dedicated labor houses. and even more Wikipedia. In modern societies, anti-homelessness legislation aims to both help and rehouse homeless people on one side and criminalize homelessness and begging on the other. So it's not just vagrancy laws or laws against being a vagrant. It's actually laws that are intended to help these people get housing and get jobs, etc., so they're not on the streets begging or causing problems. Which is good. It's better than the old joke. The law in its infinite majesty prohibits both the beggar and the nobleman from sleeping under bridges, something like that. Which of course is ironic because somebody who's wealthy and nobility would not want to sleep under a bridge. All right. Privileged words. The attorney-client privilege. Attorneys can't tell anyone what their clients told them without permission. So here's Johnnie Cochran and OJ. I guarantee you, even if Johnnie Cochran were still alive, he would not be able to tell you the things that OJ told him. Priest-penitent privilege is a general right of someone confessing sins to a priest or similar member to the clergy of any religious denomination to not have that release. So here we have a joke. It's a little cut off. Father, I have sinned. And the priest looks at Facebook and says, I already know. Which actually brings us to an important point, is these privileges aren't going to be very helpful if you told anyone else who doesn't owe you a duty of confidentiality. So if you went to the priest and you saw someone standing there next to the priest and you went through with it, that would be a problem. If you talk to your lawyer in front of, I don't know, somebody who works at the coffee stand in the courthouse and you're talking really loudly in front of the coffee stand worker does not owe you a duty of confidentiality as far as I know. So that probably would not be the brightest move to say, oh, that's privileged. He can't say that. So why did you say it in front of him? But anyway, more privileged words. Physician-patient privilege. Doctors, etc., people who are providing you with health care can't disclose your medical records without your permission or court order. There's a spousal privilege. You can't be forced to testify against your husband or wife. And there are some other issues that may be privileged: employment records, educational records, family law records, juvenile court convictions, anything that was sealed by a court. Why? Well, because the policy supporting people speaking freely with doctors, lawyers, clergy, their spouses, is more important than the law enforcement interest in that information. Makes sense if you think about it, because you'd say, well, okay, if literally the only strong evidence law enforcement has is what I said to my doctor or my lawyer or my wife or what was in a juvenile court record, maybe that's not the strongest case in the world. And okay, juvenile court, family law records, that's more just to prevent people from having embarrassing information released. Okay, a kid got caught vandalizing mailboxes when he was 12 or something like that. Maybe that's not going to be something that the court really wants on this person's record for the rest of their life, just something dumb they did when they were a kid. Same thing goes for family law records. If you get divorced, there could be some very, very nasty things in the court records, and there are legitimate reasons that they have to be there. But doesn't mean that anybody with access to the court records room, which is literally anybody, with most court cases, anybody can look at the file. So they might say, okay, somebody's dirty laundry from their divorce. We don't need everybody to look at it. We're just going to limit that to people who actually have a real need to see it. So those are reasons for some privileges. Laws people think exist, but generally don't. For example, there are mythical state health laws. I remember being told when I was in high school, this was announced over the school PA system by the school secretary or whoever it was, that we weren't allowed to wear hats in school because there was a state health law. I didn't find out till years later that there's no such thing. I was lied to by the school over the intercom. Kid did say, oh, John, you're too gullible. There's no such thing as a state health law against that, but everybody I talked to who I thought would know said, oh, yeah, it's probably just so kids won't trade hats and spread lice, but that's kind of dumb that they do that to you when you're in high school. But nope, no state health law. No shoes, no shirt, no service.
No shirt, no shoes, no dives.
Right. Learn it. Know it. Live it.
Businesses can require that you wear shoes, wear a shirt, but there is no state health law in any U.S. state. You can see the link in the description. Basically, it was just an anti-hippie rule, and because businesses didn't want to deal with people complaining, they just pretended, you know what, it's out of my hands, it's against the law in this state, I have to have you wearing shoes and a shirt. So free water at restaurants, it's the same thing. Most restaurants will give you free water. I do know of some places where the water treatment plant made water. They built a new water treatment plant and the price of water went up so much that they actually stopped giving people free water. But that's rare. Normally, restaurants, if you ask for water, you'll get it for free, but that's a courtesy, not a law. Restrooms, for employees, yes, there's a federal law that says all employees have to have a restroom to use. For customers, only in some states or cities, but not others. For example, if a restaurant has over 19 seats in New York City, they actually do have to have a restroom for customers. Did you find this video useful? Well, please like it and subscribe to this channel. Neither action costs you anything. You'll be alerted about my new videos. Why do I care? Well, it's simple. YouTube doesn't let me share any ad revenue unless I have 1,000 subscribers and 4,000 hours. That's 240,000 minutes of view time in a year. While many people are watching these, I don't have 4,000 hours of watch time. I don't have anywhere near 1,000 subscribers. For the same reasons, you're not only welcome, but encouraged to share links to this video, put it in playlists, etc. I'm always happy to read and respond to constructive criticism or suggestions for new videos, and I reserve the right to delete comments from and block those who specialize in destructive criticism. You know, trolls, or things that are off topic, kind of things that are posted by spammers and disturbed people. Thanks for watching. Have a good day.